Hello, my name is Kimberley McGhie and I am an Associate Solicitor in the Contentious Trust and Probate team here at Anthony Gold. Today I will be reacting to clips from the iconic film Rain Man, where we see Charlie Babbitt, who is played by Tom Cruise, grappling with legal issues as he tries to gain access to his late father's estate. The film highlights a number of issues that can arise when someone dies and some of the complexities faced in real-life inheritance disputes. Before we begin, I should point out that this is an American film, so some of the terms used are different to those in England.
I hereby bequeath to my son, Charles Sanford Babbitt, that certain Buick convertible, the very car that unfortunately brought our relationship to an end. Also, outright title to my prize-winning hybrid rose bushes. May they remind him of the value of excellence and the possibility of perfection. As for my home and all other property, real and personal, these shall be placed in trust, in accordance with the terms of that certain instrument executed concurrently herewith.
What does that mean, the last part? What does it mean?
It means that the estate, in excess of $3 million after expenses and taxes, will go into a trust fund for a beneficiary to be named in this document.
As in the film, in England and Wales, it is possible to set up a will trust in your will. A will trust is an arrangement that comes into effect on your death, which grants the named trustees control over the assets defined in the will on behalf of named beneficiaries. The trust might specify what is left to each beneficiary, or the trustees might have complete discretion over how and when the trustees distribute the funds. If discretion is given, guidance to the trustees can be set out in a letter of wishes.
What good is $3 million to him? That money is only just going to sit there for the rest of his life, and I need that money. You know I need that money.
You need them, so it's hardly like stealing, you know? And when it's over, what happens to Raymond?
Well, he'll go back to Walbrook or a better place. No, with the money, I will put him in a better place. What difference does it make? He is going to be just the same.
Only you have his money.
His money.
Yeah.
His money. That man was my father, too. What about my fucking half? Where's my fucking half?
You've
I'm entitled to that money, goddammit.
You kidnapped this man.
I did not take him.
Yes, you did.
I did not take him. I took my half.
In England, a person has testamentary freedom to make a will. That means a person can leave their estate to whomever they choose. This in itself can lead to an inheritance dispute, as the person not left what they were expecting is surprised and feeling hard done by. An individual might find that instead of their mother leaving their estate to all three of their children, she instead might decide to leave a legacy of £20,000 to only one of her three children, and she might leave the remaining estate to a donkey charity. Whilst the principle of testamentary freedom is important, it is still sometimes possible to challenge a will or bring a claim against the estate for lack of financial provision. As I mentioned before, each set of circumstances is different, and so if you find yourself in a situation where you think that you might need to challenge a will, we would suggest that you seek legal advice.
Pledge of Allegiance. Mark, where it stands. No.
Stu. Legally, Bruner never established a conservatorship of Raymond? Oh, he didn't figure anyone would show up to contest his authority.
Well, if that's the case, I definitely will get custody and the $3 million, right?
And you set up a date. Yeah, you set up a date for the custody hearing. Stu, I want a firm date and I want it early.
So in that clip, we see Charlie on the phone saying that there was no legal conservatorship in place over Raymond. I'd just like to flag that a conservatorship is an American term. We have something similar in England, and it is known as a deputyship. A deputy is appointed by the Court of Protection for a vulnerable person that does not already have a lasting power of attorney in place. That vulnerable person also must lack capacity to deal with either their health and welfare or their financial affairs. There's an important distinction to be made between a lasting power of attorney and a deputyship, in that a lasting power of attorney can only be made when an individual has capacity to make one, whereas a deputy can only be appointed for a vulnerable person when that person has lost capacity. So it depends on the person's circumstances as to which process should be used. Our Court of Protection team at Anthony Gold deals with deputyships and will be very willing to assist you if you have any questions about this.
No, I'm telling you, it's always been a lost cause, Charlie.
Okay, what is this about? Why'd you call me?
Well, let me tell you something. Your father put me in charge of all the money, all right? And I happen to care about your brother's life and the treatment he receives.
I made a commitment to your father some 20 years ago, and I'm not willing to gamble with that.
What is this?
It's a very big check.
$250,000.
And no strings attached. Just walk away, Charlie. You know, this isn't about you and me. It's not about winning or losing.
In that scene, we see the trustee try to settle the matter with Charlie in an attempt to try and avoid court proceedings. This is something that the parties are encouraged to do in England and Wales to try and resolve the dispute. This is because litigation is very stressful and expensive, and so it is in the best interests of the parties to try and reach a settlement if this is at all possible. In order to reach a settlement, the parties usually try something that we call alternative dispute resolution. In inheritance disputes, this usually takes the form of a mediation. This is where a mediator is jointly appointed by the parties and tries to help the parties come to a settlement. The parties can remain separate in their own rooms and not see each other at all, or a joint session could be called where all of the parties meet. It really depends on the preference of the parties. Another way of trying to reach a settlement would be to send an offer letter to the other side in the hope that a settlement can be achieved. Overall, I would say that Raymond does a pretty good job of highlighting some of the issues that can arise when someone dies. If you have found yourself relating to any of the points I have discussed, or you are currently navigating your own contentious trust or probate situation, it is important to consider if you need help and advice. Inheritance disputes are extremely stressful and emotive, as the persons involved in the dispute are also grieving the death of a loved one. If you would like legal advice on an inheritance dispute, you can email us at mail@anthonygold.co.uk, or you can call us on 020 7940 4060. I hope you have found this helpful, and thank you for watching.